Another interesting one. Thank you. Our next speaker is Mr. Toyin Adenugba. Toyin will be speaking on regulatory trends in the capital market. So Toyin is the head, rules and adjudication of NGX Regulation Limited, a wholly owned subsidiary of the Nigerian Exchange Group. Before then, Toyin practiced law at notable firms, which included the law firms of Adeketu, Caxton, Martin, and Agbo, now known as Denton ACAS Law, CG Shoeto and Co., and ALEX, Legal Practitioners and Arbitrators. Toyin is an associate of the Institute of Chartered Secretaries and Administrators of Nigeria. He's an associate of the Institute of Capital Market Registrars. He's a fellow of the Association of Enterprise Risk Management Professionals, among many others. He also represents NGX in the African Securities Exchanges Association's Policy and Regulation Working Group, and he was a member of the Nigerian Senate's Technical Committee on its review of the Investments and Securities Act and the Company and Allied Matters Act as well. Please join me in welcoming to the podium Mr. Toyin Adenugba.
Good afternoon, ladies and gentlemen. Thank you very much for joining us for this beautiful event and gathering. It is indeed a great pleasure to be here and to have such a stellar galaxy of professors and our former teachers and classmates and colleagues in attendance. I will be speaking on regulatory trends in the Nigerian capital market, and I will be speaking from the perspective of Nigerian Exchange Limited and NGX regulation. Many of you know the Nigerian Stock Exchange. What many of you might not have paid attention to is the fact that as a result of a recent restructuring, the Nigerian Stock Exchange is now called NGX Group. And it has subsidiaries, the exchange business itself, the regulation business, as well as the real estate business. I work in the regulation business as the head of rules and adjudication. Most of us being lawyers, and all of us being lawyers, we're familiar with what regulation is, which involves the making of rules as well as continuous monitoring, enforcement, and compliance with the rules. I'm speaking from the perspective of the capital markets, which is that branch of the financial services industry that is involved with the raising and formation of capital by issuing of shares or issuing of bonds for the or for long-term investments. And the whole discussion around how regulation is done in this industry and the recent events in that regard is what I intend to speak with us about today. The slides are quite many, and I'll try to go through as fast as I can before I start receiving the white card from the lady behind me. So before we go into the discussion, it would be good for us to recognize what exactly are the challenges of regulating the capital market. There is a pie chart in front of you to the credit of KPMG International, and you will see different types of problems. You see geopolitical changes. There are changes in legislation and policy. You see data protection issues and governance, which people need to comply with. You see things like credit quality, who are the kind of persons you're doing business with. You see compliance, agility. The law has changed. Regulation has changed. How quickly and how efficiently are you able to quickly adapt to the new rules and comply with them? You see customer trust. Do you have customers who have trust in you? Do you have investor confidence in whatever it is that you are doing? And this slide speaks to you about why we regulate. We regulate for the purpose of investors' protection. There is no point you bringing all your hard-earned cash and money to the market and then everything goes down the drain in any market crash. We need to be transparent, fair, and efficient in everything that we do so that there is a balance in everything that is happening in the market with regard to your market participants as well as any other person coming to do business in the market. And the objective is also to reduce systemic risk. You don't want a situation where the market is saturated with all kinds of products that you would not get quality for, and at the end of the day, you lose your hard-earned funds in that regard, or you lose entire sections of the financial services industry. So that's why we do regulation. There are all other reasons why we do that on the page there. Now, these are things that you are already aware of, but you may not have focused attention on. Thank you. That you may not have focused attention on. How we regulate is by substantial engagement. This is a subgroup of substantial engagement. You speak with people, you let them know precisely what you're doing in the market. We have rules development. I am in charge of writing rules at the exchange. You have advocacy, where you speak and explain what you're doing in the market. You have memoranda of understanding that you sign with other bodies in the market that help you to fulfill and carry out your obligations. You make use of technology, which my colleague that spoke immediately before me has explained fully about. And we also have trainings. This is like a training that we're having. In the course of regulating the markets, we came across the International Organization of Securities Commission's principles. There are 38 of them for the regulation of the markets. You have principles relating to the regulator and so many of them there. You will have the slides if you want them when we are done. We have principles for self-regulation for the SROs. You have principles for the secondary market. You have principles for issuers. Those are persons who bring their securities to the market and you go and buy and sell their shares. In the capital markets, there are many stakeholders. You have to engage with stakeholders consistently in order to have the best with regard to regulation, with regard to products, and with regard to the quality of what you receive in the market. If you look around the circle in front of you, you would see the key market participants of the markets. You have the apex regulator, you have the Ministry of Finance, you have the NGX, which is the stock exchange. Issuers, those are the companies that list securities on the various exchanges or OTC platforms. You have registrars who ensure that you get your dividends anytime dividends are declared. You have the CSCS that ensures that your shares, when you do your transactions, they get settled in good time. And there are explanations there for you to understand precisely who is what. Now you have all these people within the ecosystem. You need to know the type of regulations and laws that are responsible for ensuring that they keep on the straight and narrow. You have the CAMA 2020. I was privileged to have been on the committee that reviewed that. You have the ISA. You have the Financial Reporting Council Act and the rest of them, as you can see there on the screen before you. What you would observe from my discussion are developments that have occurred since we left school. So you are not likely to find any laws or regulation on the screen that was in existence whilst we were in school. So that is speaking to the theme of our discussion today. And then we collaborate for growth. You see the World Federation of Exchanges. You see the Intermarket Surveillance Group to ensure that the market is being properly surveilled. You see the African Securities Exchanges Association. So you have collaborating for growth in different types of industries and businesses. So you choose what fits your purpose. At the exchange, as you would understand, it is a self-regulatory organization. Now, these are entities that are non-governmental bodies and have the power to create and enforce standalone industry and professional regulations and standards by themselves. The only thing they have to do is to make sure that their regulator, the government regulator, approves their rules and regulations. So they must have the power. When you're doing regulation of the capital market as an SRO, the law requires that you must have the power, that's the Investment and Securities Act, that you must have the power to exclude persons who are not of good character and who do not possess a high degree of business integrity from the market. You must be able to expel, suspend, or discipline persons or participants for conduct that is inconsistent with equitable principles of transactions in the market. You must have conditions for listing of securities. You don't just come and list securities that people put all their money there, and then at the end of the day, they do not see the worth of what they've come to put their money in. You must have conditions governing dealings in securities by participants. Your stockbrokers must be properly regulated, and all your dealing member, your trading license holder firms must be properly regulated. And you must have a means of surveilling and regulating and supervising your markets. So these are things that you must bear in mind if you do intend to invest in the business, in the capital market. Of course, as an SRO, we would have a rule book. I led the drawing up, a review, and compilation of the rule book of the exchange in 2015. These are from old rules that we had in the market. All of them were all over the place. We had to combine everything together into one document. We spent about 8 weeks sequestered in the offices of, let me not mention their names, at Victoria Island, where we got the job done. We were successful, and we came out with a at least 400-page document. You can find it on the website of the exchange. So all the things we did there, whilst we're doing the work, you will find there. So for persons who are familiar with the exchange business, you have to be familiar with the rule book of NGX. And then when you open the rule book, it is divided into two parts. You have the side for the trading license holders. These are people that you generally know as stockbrokers. And then you have the side for the issuers. Those are entities whose securities are listed on the exchange. All the things you see in the white and green clouds on the screen before you are the themes around different parts of the rules, the different provisions of the rules in the rule book of the exchange. We're stuck. Excuse me. Okay, thank you. So, and then like I mentioned earlier, you have the issuer side. You have all types of different rules. Rules as specialized as Sukuk rules, ETFs, commercial papers, derivatives, cross-border listings. Some of us may be surprised that you are already aware that you may list a security both in Nigeria and outside Nigeria as well. So I have 5 minutes more, which is looking to me like 15 minutes. So now these are some other things that will be interesting to you. Since the new normal, COVID-19, we thank government we're no longer wearing our nose masks, but we still have to do a lot of things virtually as well. We now do electronic filing of reports. You don't need to take when I was a much younger associate, I remember then when filing returns at the stock exchange, you'd have to take your hard copy of your report and you go and stand at a gate where somebody will be peering at you like this to see whether you're a criminal or not, and then they accept your reports from you and then you can file. And many other things. Now you can just file online. You have continuous stakeholders engagement through virtual conferences like we are doing today. Some of us are joining us via Zoom. You have electronic communication channels to speak with your colleagues and your stakeholders. You have off-site inspection of trading license holders. You do not need to take your entire laptop and colleagues and everybody to go and do your inspections. You can do it online. Just make sure that you have requested beforehand all the things you want to inspect in their documents and so on and so forth. Next slide, please. Thank you. So in spite of COVID and the new normal, we continue to surveil the markets, monitor all activity. You have to do that. We continue to do compliance and enforcement. We continue doing rulemaking and interpretation. You wouldn't say because you now have COVID, you will not continue regulating the market. There is development in the market and so on and so forth. Now, you would recall that my designation is Head of Rules and Adjudication. The adjudication part deals with the disciplinary proceedings with regard to persons that fail to comply with the rules of the market. So we have virtual hearings now. I seem to recall that one of my colleagues spoke earlier about virtual hearings, about trials being done virtually. So we also have that at the exchange as well. So what we do is that if we have a room like this, we ensure that you have a wide-angle camera to make sure that everybody in the room is captured and you can see everybody in the room. You don't want a situation where you have persons coming into the room and going out at will, and you don't have a control over them. We have an agile secretariat that is in charge of everything that is being filed and all the discussions that are happening there. We have a technologically equipped hearing room for participants who are not able to join online. Just go there and seek the support you need at no fee, and then you would be able to participate in the hearing. You are all aware of the changes to CAMA 2020. You can do instruments of transfer can now be done electronically and so on. Please go back. Go back. Go back. One more, please. Thank you. So if you look at the screen, you would see a number of things that CAMA 2020, a number of positive developments that you will see under CAMA 2020. Things like instruments of transfer. You want to transfer shares to your... Please let me go back to the previous page. I'm sorry. I can use it. Okay. Previous page, please. Yes, thank you. So you can do virtual meetings. CAMA permits you to do that. But with public companies and listed companies, you have to pay more particular attention to the requirements in that regard. You can have electronic registers and documents, all the list of shareholders. You need to have quality hardware and software, though. CAMA requires that. You can do electronic filings, and you can now have electronic signatures on the documents that you file with CAC. And then this page contains different new products in the market with regard to advancements on different rules and so on and so forth. You have special purpose acquisition companies, rules on warehousing, and the rest of them, electronic offerings and so on and so forth. Yes. So, strategies and way forward. In spite of all the challenges and up and down that we're experiencing in the markets, what we are saying to you and what you should bear in mind from the regulation perspective is that compliance leaders must consider changing their requirements, supervisory priorities and reporting mandates and guidance. Compliance leaders and practitioners must be careful of fraud and abuse. Bribery, corruption, misconduct may increase during this period. So you need to pay attention to those things. You need to be able to reimagine your operations and have the capacity to respond rapidly to developments around you, your policies, oversight, and the rest of them. And then culture and ethics and the rest of them, you need to pay attention to them. Response and recovery time is very important. And RegTech is of extreme importance to you. I think that is the last page. Thank you very much for listening.
So for Toyin, in your experience, are there cases of conflict between or an overlap of regulatory powers? How do you resolve this at the regulatory level? And what advice would you give practitioners caught in such situations? So you can take the two answers when you get the mic shortly.
I have just one or two comments in some areas. Now, for the regulators, yes, I'm just wondering whether, in the compilation of these rules and regulations, there is also some housekeeping done to ensure or to eliminate conflicts. Because sometimes when you look at the rules that you have in the rule book and you match it with the SEC consolidated rules of 2013, you do run into conflict situations. Then what happens? At what point in time should we be conducting this kind of stock taking so that we can eliminate those kind of conflict situations? Then you look at three related rules. First of all, you take CAMA, you take the ISA and the rules, and then of course the rule book of 2015. The purchases of so when you look at that and you see conflicts, the ISA talks about the conflict between ISA and perhaps CAMA, and ISA overrides when it relates to market operations, which is never defined in that act. However, so when you then have rules that negate on the face of it the provisions of ISA, when you have ISA act or rules that negate the provisions of CAMA, how do you resolve it? Particularly when they do not relate to market operations. Why should there be conflict between the SEC rules and the stock exchange rules? There shouldn't really be, but there are conflicts. So those are some of the concerns I have that I want you to note.
Thank you, Prof, for the two questions that you raised. I would start with those ones. You had asked whether, with regard to rulemaking, we have any housekeeping to eliminate conflicts within market rules, the SEC consolidated rules, the NGX rules, and the rest of them. Yes, we do have a bit of housekeeping. We have what you call the rulemaking procedure of the exchange at the exchanges level. I wrote the first draft of the rulemaking procedure of the exchange in 2013, and then we have, as time has gone on, improved it. What we have in the course of making the rules is we start with what you call a rule owner, who is usually a subject matter expert. That is the person who comes up with the proposal when you want to make the rules. This person is expected to be familiar with market practices, legislation, regulation, as well as international best practices in that regard. So that person brings that experience to bear in what is written, and then we have a committee that is made up of experts in the capital market, members of the board, staff members who are subject matter experts, as well as stockbrokers or representatives of listed companies on those committees when they consider the rules. They are bringing to bear experience as well with regard to practice, legislation, and regulation. And then the biggest one is exposure for stakeholders' comments. And then the documents or whatever it is, the rules we're exposing, are put on our website for the total exposure period. The website has a free access. Anybody can access it. And you send your comments to the exchange in any form. Through that medium, we gather all the comments from stakeholders and use it to improve the content of what we have. It is a process that is painstaking. We gather all the comments. I'm sure my friends would make fun of my glasses. They've become thicker over the years because I have to gather all the comments and respond to them the way I'm speaking, as if I'm speaking to you now, and take all the comments to the committee. Where I have responses that are not sufficient, I will be ordered to go back to do further research to satisfy what they are asking. And of course, it is expected that whoever is going to sit in the position of the head of rules and adjudication or the rules and interpretation officer or the disciplinary manager must first and foremost be a lawyer. Secondly, must have practiced, within this jurisdiction and have some experience. So we expect you to bring all that experience to bear in what you're doing whilst you're drafting. But of course, you remember that stakeholder intervention and comment and engagement is very, very important. So that helps us with regard to the housekeeping you're talking about. And then with regard to conflicts between provisions, we do understand the hierarchy of laws as well. And we know that when you have regulations for the capital market, you defer to the ISA. And of course, when you submit the regulations you have drafted at the exchanges level, you submit to your regulator. Every piece of regulation you have drafted at the exchange, or any amendment to any regulation, must be approved by the commission before it gets into law. So we expect that even if we have made a mistake at the exchanges level, the commission will catch it. And even if we made a mistake in the course of exposure for stakeholders' comments, somebody in the industry will catch it. They're always harassing us from with regard to the rules we expose for comments. So we bring that into board, and then we take that on board, and then we make the corrections that we need to make so that the document is best for the consumption of our stakeholders. Where we have conflicts in provisions with regard to, let's say, from the CAMA's perspective or the ISA's perspective, I think stakeholder engagement, because I was asked that in my experience, what has happened. I was part of the Senate's technical committee on the review of ISA and CAMA in 2017, 2018. And then you have to join this network that is called the National Assembly Business Environment Roundtable, Experts Network, where they bring in persons who are familiar with these provisions to improve the ease of doing business in Nigeria. So anytime you are making these laws and new rules and regulation, you have something at the back of your mind to ease the doing of business. And then people who are familiar with this thing come with that understanding and knowledge to whatever it is they are contributing to the rulemaking. So in that regard, it is expected that that synergy of experts and collaboration with the regulators of the industry in respect of which you're making the rules would help you to avoid those kind of conflicts. And of course, everybody should understand their turf. When you're talking about money market, that's the Central Bank of Nigeria. When you're talking about the capital market, that is the Securities and Exchange Commission. When you're talking about the administration of companies and rules and meetings and incorporation, you know that is CAC. So everybody should know their turf and not attempt to encroach into other person's stuff. Where you find that in spite of all those engagements, you still find that there are still conflicts, the best thing to do is to engage with the stakeholder or the regulator. Substantial engagement has been found to be very, very important. And of course, you engage with your regulator in a way that is constructive, not in a way that will tick off your regulator, get them upset with you. You are the one that is bringing the transaction to the market, billions. And the regulator has, I shouldn't say that, but I won't finish that statement. So you should engage in a way that is constructive so that you're able to carry out a transaction, satisfy your clients, deepen the market, enhance growth and development, and also improve legislation and regulation as well. Thank you very much.